Hello, and welcome to this talk about bringing your claim for judicial review, in which I'm going to talk about remedies in judicial review. My name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers. The court requires you to be clear about what remedy you're seeking throughout the case. Section 7 of the claim form asks you to state what remedy you're seeking from the court if you're successful. There are 6 remedies which are listed in sections 31.1 and 31.4 of the Senior Courts Act 1981 and mentioned in the Civil Procedure Rules Part 54. These are a mandatory order, a quashing order, a prohibiting order, a declaration, the rare declaration of incompatibility, injunction, and there's also damages. However, before looking at these various types of remedy, one important point needs to be noted. If the court considers that the outcome for you, the claimant, would not be substantially different than the outcome that actually occurred, then the court has a duty to refuse to grant relief. So let's look at that. So what the court has to consider is whether it's highly likely that the outcome for the claimant would not be substantially different, even if the unlawful decision by the defendant was set aside or remedied. In those circumstances, the court must refuse to grant any form of relief and mustn't award damages except in exceptional public interest cases. Remember that the remedies awarded in judicial review are discretionary remedies. They are, as the Administrative Court Guide says, within the discretion of the court. Now, what this means is that you can't get a remedy as of right, and the court can refuse to grant a remedy in particular where, for example, the claimant's delayed filing the application for judicial review and the court considers that granting the remedy sought would be likely either to, 1, cause substantial hardship to or substantially prejudice the rights of any person, or 2, would be detrimental to good administration. Another factor that will affect this discretion is where the public body's error of law isn't material to the court's decision, so that although they can identify that there was an error of law, actually it doesn't make any difference to the ultimate decision. It's not a relevant error of law. Next, if the remedy you're seeking serves no useful practical purpose, then the court in its discretion may well refuse relief. Next, if you've suffered no harm or prejudice, then the court again may not award relief. It's important to notice, though, that these principles on discretionary remedies, this aspect of discretionary remedies, doesn't apply to the award of damages. And I'll say a bit more about the award of damages in this context later on. So let's turn to the actual orders that you may get from a judicial review court. First of all, there's an order called a mandatory order. In Latin, this used to be called mandamus, and you'll sometimes see it referred to in that way. What it does is to mandate or compel the public body to do a specific act. So, for example, to consider their decision that you're challenging afresh. You can request one of these orders by saying what you want the public body to be compelled to do, and you should make it clear in your claim form that you're seeking a mandatory order. A quashing order, this sets aside or quashes the decision. It confirms that the quashed decision has no lawful force and no legal effect. Now, sometimes you'll see the Latin word certiorari referring to this type of quashing order. But these days, English is the preferred way of talking about these things, so don't use these Latin tags as a way of buying your way into the good graces of the court. It won't work. So what happens with a quashing order? Well, generally the court will remit the decision back to the decision maker and direct the decision maker to reconsider the decision and to reach a fresh decision in accordance with the court's judgment. So the court may have indicated certain factors that need to be taken into account in that decision-making process. The court can substitute its own decision, but only in certain cases. These are cases concerning the decisions of lower courts, inferior courts, or tribunals, and only on the ground that there has been an error of law, and only where there's only one possible decision now open to the decision maker. A prohibiting order prohibits a public body from taking an action. It'll be an action that the public body has indicated an intention to take, but has not yet taken, and the order is designed to prevent future unlawful action. A declaration is a remedy which is available in the civil courts generally, and it's available in the administrative courts. It's a statement by the court on what the law is or is not concerning a particular point. The remedy of declaration allows the court to examine a public body's act, including an act which has been announced but not yet taken, and to formally declare it to be lawful or unlawful. This declaration has no coercive force, but there is an expectation that the public body will comply with it. It is not to be used for hypothetical cases or cases in which you don't have an interest directly, and it will not be granted if the declaration is sought without proper argument. So, for example, where judgment's being entered in default of a defence being put in, or if there have been admissions, or if the parties are asking for the declaration to be made by consent. The administrative court is, of course, a branch of the High Court and therefore can grant injunctions. These are orders to act in a particular way, a positive injunction, or an order to refrain from acting in a particular way, and that would be called a negative injunction. On my YouTube channel you can find my other talks on injunctions generally, and the same rules apply to whether or not they'll be granted. You can see in particular the rules relating to the grant of interim injunctions. The administrative court does have power to award damages, but it is a highly limited power. You can only seek damages if you're also seeking another remedy and not just damages alone. Secondly, you can only seek damages if a private law claim, so that would be claims for things like breach of statutory duty or breach of contract, etc. So if a private law claim for damages on the same basis would have succeeded if it was brought in the county court or the appropriate division of the High Court. In practice, if the assessment and award of damages is likely to be lengthy, the court will determine the applications relating to the judicial review claim, award any other remedy that's being sought, if that's appropriate, and then transfer the claim to either the county court or an appropriate division of the High Court to determine the question of damages. Finally, I want to mention a rare remedy called the Declaration of Incompatibility. Now, this is a declaration, but it's a declaration under the Human Rights Act 1998, and the court determines that an Act of Parliament, or a statutory instrument, is incompatible with a right which is contained in the European Convention on Human Rights and Fundamental Freedoms of 1950. This is the international treaty that was incorporated into UK law by the Human Rights Act 1998. In the case of subordinate legislation, the court will make a declaration of incompatibility if it's satisfied that in the absence of Parliament revoking the primary act or parent act, So that's the act which allows the subordinate legislation to be made. So absent revocation, if the court considers that the Parent Act prevents the removal of the incompatibility with the Convention on Human Rights, then it will make a declaration of incompatibility. The declaration doesn't affect the validity or continuing operation or enforcement of the provision which has been successfully challenged, and it doesn't bind the individual parties. It triggers a process within Parliament. If you are seeking a declaration of incompatibility, you must state that this is what you're doing in Section 7 of the claim form, which deals with remedies. You must give precise details of the particular convention right which you say has been infringed, and the particular provision of the UK law which you say is incompatible with that right. You should consider making the Crown, via the relevant Secretary of State, an interested party. And if you make an application for a declaration of incompatibility, the court may order that notice should be given to the Crown and the Crown be given opportunity to intervene. Moreover, if the court is considering making a declaration of incompatibility, the court is obliged to tell the Secretary of State and to give at least 21 days for the Secretary of State to consider intervening and making representations on the question of whether a declaration of incompatibility should be made.